I'll be honest, I have been busy. Life has been moving, work has been piling up, and I genuinely had no intention of revisiting the NewJeans situation this soon. But when the news dropped that Daniela's exclusive contract had been terminated, I didn't gasp. I didn't clutch my chest. I didn't even blink. Because if you've been paying attention, not emotionally, but legally, this outcome has been written on the wall for months. I also wasn't surprised because Danielle's public behavior had already crossed the invisible but very real line that exclusive idol contracts draw. The photos circulating online, marathons, volunteer events, brand exposure, watches, logos, were not harmless lifestyle posts. They were commercial activity, and in entertainment law, intent does not matter nearly as much as effect. And the effect was this: she acted independently while still bound by a valid contract. So let's be very clear about what happened. Last year, all 5 members attempted to unilaterally terminate their exclusive contracts, claiming a breakdown of trust. The court rejected that claim in full. The ruling reaffirmed that their contracts remain legally binding until July 31st, 2029. That ruling is not HIBE bias. It is contract law functioning exactly as designed. Following that ruling, Ador attempted reconciliation. Haran and Hayin returned. Haney returned after traveling to Korea and reassessing the situation. Minji remains in discussions. Danielle did not. Instead, Danielle did the following: unauthorized commercial appearances, solo advertising contracts, public-facing brand signaling through watches, apparel, and endorsements that were not cleared through the agency. The Omega situation, which is particularly damning because it was originally a group opportunity. The documented refusal to comply with corrective requests, the instruction to reroute communication exclusively through legal counsel while continuing conduct the agency had explicitly objected to. Now, you may be wondering, why do all these things matter legally? I'll break it down now. First, the Omega contract. Looking at it, this is categorized as usurpation of corporate opportunity. Ador will argue that since Omega initially contacted the group, Danielle taking it as a solo deal after declaring termination is a direct theft of Ador's business assets. Secondly, the correction period. Under the South Korean standard exclusive contract, an agency must give an artist a 14-day grace period to fix a breach. By documenting her refusal to comply during this window, Ador has legally paved the way for a termination for cause, which carries much higher financial penalties than a mutual split. Number 3, rerouting to counsel. In civil law, this can be used to prove irreparable breakdown of trust. Ador is arguing that while they tried to broaden mutual understanding, as they did with Haney, Danielle's team intentionally blocked mediation to pursue independent profits. Because these acts involve global brands like Omega and billions of won, the damages claim is not just for the training costs, but for the lost commissions Ador would have earned from these deals. And people keep throwing around numbers like 80 billion won, 100 billion won, like they're abstract symbols of punishment. They're not, they're calculations. Exclusive contracts in K-pop are structured to project forward-looking loss. When a member breaches, the company doesn't just ask, "What did we lose yesterday?" They ask, "What would we have earned if this asset had remained intact?" That's how you arrive at numbers that make people uncomfortable. And here's the part fans truly don't grasp. This is civil liability, which means it doesn't end neatly. I need to make one thing crystal clear. If Danielle cannot pay this debt, and let's be realistic, with a potential liability north of $80 million, that debt doesn't just evaporate into the ether. It becomes a permanent, legally binding shadow that will follow her for the rest of her life. In the legal world, we don't just win a judgment and walk away. We collect. Under the Civil Execution Act, Ador has a literal arsenal of tools to ensure they get their pound of flesh. They can move for a wage garnishment, meaning a significant portion of every paycheck Danielle ever earns, whether she's modeling in Paris or working a desk job in 10 years, is legally diverted to Adore before it even hits her bank account. This isn't a temporary setback. It's a lifetime tax on her existence. And don't think for a second that her Australian citizenship provides a sanctuary. We have what are called reciprocal enforcement mechanisms, specifically under Australia's Foreign Judgments Act 1991. South Korea is a recognized jurisdiction of substantial reciprocity. Adore doesn't have to relitigate the entire case in Sydney. They simply register the Korean judgment in an Australian court, and suddenly it has the same power as an Australian order. They can seize her Australian assets, her property, and her bank accounts with terrifying efficiency. And agencies, brands, and broadcasters will hesitate not because she's canceled, but because unresolved litigation is a financial risk. Because why would a luxury brand sign a spokesperson when they know that any fee they pay could be seized by the company, or that they might be dragged into a co-defendant lawsuit for tortious interference? And Adore did not involve Danielle's mother for optics. They did it because they believe they can prove interference. In Korean civil law, inducing breach of contract, tortious interference, is actionable. And it is far more powerful when the alleged interferer is not another corporation, but a trusted personal authority figure. If Adore can demonstrate that Danielle's mother coordinated with Min Hee-jin, facilitated independent deals, provided misleading information to other families, or actively delayed members' return, then the narrative shifts completely. This stops being young artists misled by management and becomes adult-driven orchestration. And by suing the mother and Min Hee-jin as joint tortfeasors, Adore creates joint and several liabilities. This means Adore can go after the mother's assets, her real estate, her savings, her investments, to satisfy the debt. It's a strategy designed to ensure that even if Danielle's accounts are emptied, the company has other avenues to reclaim their massive investment. And something like this is exactly why Honey is back in the studio while Danielle is in a courtroom. Honey's rectification, coming back and admitting she was misled, allows her to play the victim of bad information. Danielle, by continuing her solo activities like the Omega deal and refusing to talk to the agency except through lawyers, has effectively leaned into the orchestrated role. And I know people want to moralize Hanny's decision. I don't. Her return didn't read to me as betrayal or cowardice. It read as survival. She saw what continuing resistance looked like in real time. She saw the numbers. She saw the legal scaffolding closing in, and she chose containment over destruction. That doesn't make her noble. It makes her pragmatic. And Adore didn't bring her back out of kindness. They brought her back because she still holds value and because keeping her stabilizes what remains of the group. That's business. Nothing more, nothing less. And as for Minji, she's got to make a decision soon. According to industry insiders, it's noted that she's the closest to Danielle than to Hanny. So my take is, if she joins Danielle, she faces professional exile and astronomical debt. If she joins Hani, she has to return to a company she publicly denounced. Excuse me for sounding harsh, but to those tokies blaming Elit for this, y'all should shut y'all smelly, goofy asses up. Anyway, if the allegations against Danielle and her mother are accurate, if group opportunities were redirected, if other members were misled, if independent profit was prioritized while the collective burned, then this outcome was not accidental. It was invited. I'll continue watching the filings. Discovery will expose everything. It always does. When that happens, I'll talk about it again. Hopefully I'd be less busy then. But as of today, the version of NewJeans people believed in no longer exists. Not because of malice, because of law.